the here and now. Thank you very much, Jan. Let me introduce this subject about cross-border aspects and effects for licensing, collective licensing. Let me first, when you go home, I can recommend you to read one paper on this. LIE has, or in September 2016, written an opinion on this subject, cross-border effects. And I think it's a really good paper to read. I warmly recommended it, and it gives you lots of wisdom, and it's inspirational. Now, the first problem with regard to this issue, cross-border licensing, and that is the issue of applicable law. That is the whole crux of the matter. And as many, for example, James Ginsberg already said yesterday, we have the Berne Convention, Article 5, Paragraph 2, and then there's also the principles in international private law about jurisdiction and which legislation should apply, and this is based on that it's the law of the country where the use is taking place that applies. So when you're looking at what's legal, what's illegal, that's what determines. And a management organization can obviously conclude an agreement which stretches across to another country. There's not a problem in that a Finnish management organization concludes an agreement with a Finnish educational establishment which exists around the world. There's a repertoire and agreements, etc., but this is not a problem. There's no hindrance to that. But the problem arises is the ECL and the extension of the agreement above and beyond the rights that are represented to what you don't represent in the license. And the problem is that if we're talking about a collective agreement with a Finnish educational establishment, and then obviously, if the Finnish license, there's photocopying instance that takes place in the premises of this establishment in Finland. However, if the agreement also includes students that perhaps go as guests to other organizations, say in Denmark, then that copying that student does there, then it's on Danish territory, and therefore it is not covered by the Finnish license. And Jane Ginsberg briefly touched upon this on applicable law yesterday, and there the question arose whether there are different types of laws that we're discussing, really, if we're talking about contractual law or not. I think it's about a contract that has been agreed with the management organization, with an establishment. So it's not just a legislation where the contract was concluded, in Finland, and then there's no problem. Because in my view, that is not the case. Because I believe that what's decisive is what we call lex loci delicti. It's where the use takes place. Because we're not talking about interpreting a contract or dispute between two contractual parties. No, but it's about expanding the contract in relation to a paragraph in copyright law, which is why I'm saying that lies outside a contractual law, and also. So we're talking about that the law applies where the use is taking place. So it's the extension. It's not the contract itself that's the problem. It's the extension thereof. And so we have a problem in relation to using these licenses when you have ECLs, for example, outside your own territory. And this problem can be solved voluntarily. For example, you could say that the Nordic CMOs in any given area can, for example, have some kind of cooperation with sort of mutual approval, recognition, where you do something together, which means that the problem will be resolved of its own accord. But the thing is that this type of voluntary agreement or resolution doesn't make everybody safe and sure. It's not a safe and sound solution to this problem. And bearing in mind the challenges that we have with cross-border issues, with internet, etc., where the Commission, for example, is trying to use ECLs for this, if you're going to try to avoid regulating something, then these ECLs can be used in a cross-border situation. And if you have a good solution for that, then you can decide to make exemptions from copyright rather than making what I think we're all agreed on. The best solution is agreement-based or licensing-based situations, models. And this cross-border effect in relation to ECLs is increasing because the problems there with it is increasing because, as we had yesterday, ECLs are being used more and more also within relation to use on the internet. And previously in the Nordic countries, we've looked at the government levels, for example, the Nordic Council of Ministers, to try to find a solution to this problem. And Helge Søderland from Norway, who's really been working with this and looking into whether it would be possible to have some kind of Nordic agreement between the Nordic countries where you then have a mutual recognition of each other's ECLs. It's never led anywhere, and one of the reasons for this is that this type of separate Nordic agreement would go against EU rules, in that it would give a group of right holders benefits and others would be discriminated against on account of nationality. And in relation to a memorandum of understanding of out-of-commerce works, there's also been looking into whether it would be possible to have this mutual recognition. However, nothing has come of that either. Now, for the Nordic governments, they are fully aware of the fact that it is important to find a solution to this problem so that you can continue to use ECLs in relation to cross-border use. And in 2016, in fact, they sent a joint letter, the 5 Nordic countries plus the Faroe Islands, to the EU Commission, where they wrote that we are confident that it's possible to find suitable solutions for this issue, in other words, with regard to cross-border use and ECLs. And so, as the situation stands today, there doesn't seem to be anyone has found the sort of general solution to this problem, and mutual recognition within the EU is, of course, I would say, the best solution. But before we arrive at that point, when we have that, I would say that the second best solution is the one that we have in Article 4 of the proposed directive of copyright for the digital single market, in relation to education, for example, where you have what you call a legal fiction. A legal fiction based on the example that I used before with a Finnish student that goes to Copenhagen, that copying that takes place there that isn't taking place in Denmark, but in fact in Finland. And the legal fiction is that it's the Finnish ECL can be used in that way for the Finnish student copying, regardless of the fact that it actually in practice takes place in Danish territory. And as legal fiction is very dangerous, however, because if you expand that principle more generally, then of course you will undermine copyright protection. So that's why in recitals to this proposal, the Commission, has especially linked to this educational establishment, because you have an establishment at a particular. You can do it this way because you have an establishment which is linked to and a student which is linked to that establishment, and that's why you can do it in that way. But when I think this legal fiction is a very good solution with care. It's the second best solution apart from mutual recognition within the EU, for example, which is what LA is recommended in his opinion. Thank you very much.